Now we are. I see the red light.
Yes, I see.
Good morning. Let me welcome you to the Kansas Court of Appeals Zoom oral arguments. This is the second of three cases we have here today. This case is State of Kansas versus Janet Allen, number 121916. I'm Gordon Atchison. I'm the presiding judge. The other members of the panel today are Judge Kim Schroeder, who's been a member of our court since 2013. Most recently, before that, he was a district court judge in Southwest Kansas for 14 years. Also joining us today is Judge Sarah Warner, who is the newest member of our court, having joined us last year from private practice in Lawrence. I just passed my 10th anniversary on the court, and I was in private practice for a long time before that, mostly in the Kansas City area. I will remind counsel that unlike our in-person arguments, we are streaming live on YouTube, and this argument will be recorded and archived for posterity. I will also remind counsel we have read the briefs. We're sort of generally familiar with the facts. And if I could have the appearance of counsel.
Good morning. I'm Rick Kittle, representing the appellant Janet Allen.
Good morning, Your Honors. Michael Duenas, Assistant Solicitor General, representing the state.
Okay. Mr. Kittle, as the appellant, do you wish to reserve a portion of your 15 minutes for rebuttal?
Yes, Your Honor. 3 minutes, please.
Okay. And this is set for the standard 15 minutes per side, and we'll go ahead and proceed whenever you're ready, Mr. Kittle.
Thank you. In this case, Ms. Allen was found guilty of forgery and 2 counts of theft, one which was a misdemeanor, one which was a felony. You've indicated that you've read the brief, so unless the court asks questions about the facts, I would move to the first issue in Ms. Allen's brief, which concerns basically 2 things. It concerns her right to a speedy trial, statutory right to speedy trial, and her right to be present at all critical stages of the proceedings. There seems to be no doubt in this case that Ms. Allen was not brought to trial within 180 days after her arraignment. And in the brief we filed, we note that there were times early on in the prosecution when time was charged to Ms. Allen. Some delays in the proceedings were charged to Ms. Allen because we have journal entries indicating that the period from May 24th, 2018 until June 28th, 2018 was charged to her, as was June 28th, 2018 until August 9th, 2018. But on August 9th of 2018, defense counsel requested a trial setting. And so at that hearing, trial was set at the last week of January of 2019, which according to the district court's calculations would have been about a week and a half prior to the expiration of the 180-day period on February 9th of 2019. So we have trial scheduled the last week of January 2019. Court also sets a pretrial hearing for the first week of January 2019 on January 3rd. Now, the record on appeal that I had when I drafted Ms. Allen's brief gave no indication that after the point that her attorney asked for a trial setting, any further delays in the case should have been charged to her. But clearly, there was no pretrial hearing held on January 3rd, 2019 has been scheduled. And instead, what we have in the record is the state actually asking for a continuance because one of its witnesses apparently was not going to be available during the last week of January 2019, the week that the trial was scheduled. Again, the record on what exactly happened here with this continuance is not completely clear, but what is clear is that the trial did not happen as scheduled during the last week of January 2019. And the trial actually took place in May of 2019, which would have clearly been outside the 180-day period. After Ms. Allen's brief was filed, there was this volume 11 added to the record on appeal, which consists solely of an email exchange between Mr. James, the prosecutor, and Mr. Rombold, Ms. Allen's attorney at the district court level. And my understanding of this is that the state is relying upon this email exchange to show that somehow the time after that request for a continuance, or the time after the original trial setting in late January of 2019, should be charged to Ms. Allen. On this point, I would first argue that I don't think we should be relying upon an exchange of emails. This was not a document that was ever filed in the district court at the time. There doesn't appear to be any involvement, direct involvement of the district court in this matter regarding these emails. There certainly doesn't appear to be any involvement of Ms. Allen in obtaining this continuance. And I would note that this was a continuance asked for by the state. So how is this time supposedly charged to the defense?
Where does that ultimately leave us at this point, Mr. Kittle, in your view? I mean, what are we supposed to do with this mess that's been handed to us?
Well, this is really a problem in two parts. At least that's the way I'm dealing with it in my brief and what I see. I see that there is a denial of Ms. Allen's right to be present at every critical stage of the proceedings, because the Kansas Supreme Court in Wright said that she has a right to be present at a hearing where there is a continuance decided.
Okay, assuming we agree with that, okay, where does that take us?
Well, I think if that's problematic, if her right to be present is violated, I don't think you can rely on what the state is putting forward as proof of how this time should be distributed. That time should still be charged to the state. It doesn't, and I think logically it would be charged to the state anyway, because it was the state's continuance. It was the state's witness that wasn't available for trial at the end of January. Then we look at, when was the trial held? The trial was held in May, which is clearly outside the 180-day period. Now, one of the things that the state has done in its brief is it's tried to distinguish Wright by saying that in Wright, the facts indicated that the defendant in Wright was writing letters to the court, making communications to trial defense counsel saying, I don't want any more time charged to me. And I agree, we don't have that type of thing in the instant case. We don't have an indication in the record that Ms. Allen was writing letters to court or counsel about this matter. But what the state is...
Let me play out what I seem to get from this, and what I get from the speedy trial statute is the speedy trial statute has an exception that allows the court to go beyond the 180 days that would apply here if there is evidence that's unavailable. And you have a hearing and the judge says, okay, I find that there's this important evidence that's unavailable, and I don't have it in front of me. I think they can grant a continuance for 90 days. And so does that figure into this somehow at this point, is that that's a possibility, and that the trial, in fact, could have been held on May 7th if the court had granted or did grant that exception?
I think the problem with that, Your Honor, is we don't have any indication in the record that that's actually what happened.
Well, and so and that gets me back to my original question of what are we supposed to do in that circumstance?
Well, because the obligation is entirely upon the state, and this is what I was referring to when I was just talking about Taylor. Yes, there are factual distinctions between this case and Taylor, but the problem is, and what the state has failed to acknowledge here, is what we're talking about is the defendant's statutory right. The defendant doesn't have to do anything to assert her statutory right to a speedy trial. The obligation is entirely upon the state to bring her to trial within the statutory allowed period. And because that didn't happen here, and because there's not a record to show that there were any justifications for extending the period, and there's no
indication. What if, and I'm not saying that this happened here, but what if defense counsel agreed with the state that, okay, we'll agree to a continuance in light of the fact that this witness is not available, evidence isn't available, and thus we'll agree to this extension that exists under the speedy trial statute under E2?
Well, I'd say there's no indication in the record that that's what actually happened here. I mean, there has to be some documentation in the record to apply those principles of law, and we just don't have that here. And since it's the obligation of the state to bring the defendant to trial, I would argue it's their obligation to fill in the record, any holes in the record to show what's happened, and an email exchange at which the defendant's right to be present is not protected. And the judge, apparently, the district court judge, doesn't have any connection with this either, doesn't satisfy what's required here.
Counsel, did the state provide in the record anywhere the nature of the witness who couldn't be present as to whether they were a critical or non-critical witness?
I don't think that was, at least when I wrote the brief, I didn't see anything identifying who this witness was. Now, it seems to me that when the state wrote its brief, it may have tried to flesh that out a little bit more and explain who this person was, but I'm sorry, I don't actually recall who that was, but I know that when I wrote the brief, I didn't have any indication, there was no indication in the record that I could find as to who the person was.
Well, and I haven't been able to see where there's an actual finding by the court for good cause to continue the trial in late January. Is that true?
That is my understanding as well. I mean, in this case, we just don't have a very fleshed out record of what happened with regard to these continuances. It doesn't appear to me that there was ever actually any hearing on this continuance that was requested by the state. It's just that we have this email exchange, and then all of a sudden the trial is not happening when originally scheduled.
So then
go ahead.
Are you asking the court here then in that situation to remand for the facts to be fleshed out?
No, I'm not asking for a remand. I'm saying that my client's right to be brought to trial within 180 days has been violated. Clearly, this was outside 180 days, and there simply is nothing in the record to justify charging the extra time to her. And the remedy in that situation is just a reversal of conviction and a discharge from further prosecution because the state has not met its statutory obligation.
You're at the end of your opening. You have your rebuttal time still. Mr. Dunas, we'll hear from you.
Good morning, Your Honors. May it please the court. I think there's some facts that we do know. There may be a bit of a mess here in terms of what the facts are, but I think it's important to bring in the facts that we do know. And the first of those is that the speedy trial concerns were clearly on the record at more than one point. In other words, both parties and the district judge were aware that there were speedy trial issues, that the clock was running. I would just point to the same date that defense counsel has pointed to in August 9th of 2018, when the clock began. The court there said, I think we're looking at today's, first of all, the court said that the state wanted to assess all the time thus far to the defendant because of pending motions. And defendant was present at that particular hearing, and there was no objection to starting the clock at that point. There was no objection to starting the days and setting the trial in late January at that August 9th, 2018 hearing. So I think anything that came before that really is sort of immaterial. All that could be charged to the defendant because the defendant never made any objection to that. I think what's also important is that in that motion to continue that was filed on the 2nd of January in 2019, the state clearly put in that motion that it had coordinated with defense counsel and that attorney for defendant, that the defense counsel relayed he had no objection to a continuance and defendant had previously waived speedy trial. So we do have a statement there, and I think that leads into the emails. So the reason,
counsel, where does it say the defendant waived speedy trial?
Well, it says it in the motion to continue. The motion that was filed there stated that defendant had previously waived speedy trial. Now, I will confess, I didn't find anywhere in the record where there's an explicit statement that she had waived speedy trial. So I will concede that point. I don't.
So where are you at on the issue of her right to be involved or have a hearing on continuing the trial for late January as a critical stage of the proceedings?
You mean to have it continued from to late January or from January to May?
No, from January to May. It appears that from opposing counsel that that was done by phone calls or emails, but there's nothing in the record that reflects that she was present to voice her concern or agreement with a continuance.
Yeah, I agree. I mean, my understanding of the facts are that the trial was set for late January. On the 2nd of January, that's when the state filed a motion for continuance because a particular witness wasn't going to be available and was going to be working in Montana. But in that motion, he had stated that he'd already coordinated with defense counsel. I think the case law says essentially that, in the absence of opposition, the actions of defendant's counsel are going to be attributed to the defendant.
Except on a speedy trial issue, and it doesn't matter whether it's a constitutional or a statutory one. Kansas Supreme Court said that's a critical stage of the proceedings and that the defendant has a right to be present. And if it's just coordinated by counsel, that right has been violated, hasn't it?
Not necessarily. I would point to McDaniel, which defense counsel cites, says the scope of the right to be present is influenced by circumstances and context. It extends to any stage of the criminal proceeding that is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure. In particular, the court has examined whether or not exclusion of the defendant interfered with the defendant's opportunity to test the evidence introduced against him and whether or not it otherwise affected his opportunity to defend himself at trial. I don't believe that those happened here. In other words, there's absolutely no evidence at any point that the defendant ever had any opposition to the time being counted against her.
Counsel, isn't that the problem though? Isn't that the problem, that there was never a hearing whereby the defendant could either consent to this continuance or not consent to the continuance? We don't have any findings on the record about that.
Well, I think it's a problem only if you're talking about what happened in January. In other words, we had a hearing in May, there was something happened in June, there was something happened in August. In other words, all of these times, the speedy trial issue was before the parties. It wasn't something that was kind of hidden in the background. It had come up at every one of those, and there was no indication from the defense counsel or the defendant who was present at those that she ever had a problem with those being attributed to her. But I would make the further point to say that what I think happened is that if we take it as a fact that what the motion to continue says, that defense counsel and the state conferred together, and assuming that he conferred with his client and said there's no objection, then the email that came from the district court and said, hey, can we have a May 7th and 8th date? That happened all because there was already an agreement that was in the motion.
You've just assumed away the basic problem is there's nothing to show that the defendant herself agreed with this. And that's the whole point of having the hearing. And it seems to me in Wright, the Supreme Court said that's a critical stage and you have to have a hearing and the defendant has to be present. And that didn't happen in January.
Yeah, I would.
That's a problem. I mean, isn't it?
I don't believe so, because I would distinguish Wright, I would distinguish Dupree, I would distinguish Brownlee, in that they're all the same, in that you had significant evidence in the record that the defendant didn't want continuances or the defendant had a speedy trial concern.
Well, I understand those were the facts, but in Wright, the state Supreme Court said a continuance of the trial is a critical stage and the defendant has a right to be present, to be heard. And I don't see how you can circumvent that right by simply not having a hearing. I mean, maybe I'm missing something. I mean,
I don't see anywhere in the case law that says you're required to have a hearing if the parties agree to. In other words, if she's agreeing to acquiesce to a waiver of speedy trial, but I would just point to McDaniel.
But counsel, isn't that the fact we don't know whether she agreed and only her attorney did it on his shoulders? Or
I would cite the holding from, I think, Vaughn and Dupree that says the defendant must have an opportunity to be present to express disagreement with a continuance because the defendant's disagreement matters in the statutory speedy trial analysis. And in Vaughn, the court says, for acquiescence to result in a waiver of speedy trial rights, the state must demonstrate more than mere passive acceptance, must produce some evidence of agreement to the delay by the defendant or defense counsel. And here we have evidence. I think the defense counsel representing the client was agreed to take the time from January until May. And I would point out that there was no filing. In other words, the decision was made in early January. The trial wasn't set till late January. There was no response to the state's motion to continue. In other words, defendant could have said, no, I don't want that.
Counsel, I hate to interrupt you, but assume that we don't disagree. Assume that we disagree with you, and that we think that right controls in this case. So if that's the case, and if right controls, where does that leave us? Does that mean that this requires dismissal, or does that mean, like right, we have to remand for findings?
I don't believe it requires dismissal. I'd say at the most, yes, it would require that you take the procedure, which defense counsel also mentioned in his brief. That, I mean, I know he's asking for, he's asking for more than that here, but I think in his brief, and I believe it's consistent with right, that we argued in our brief that there would be a remand to go back and discuss the facts or do some more fact finding as to what actually happened in early January. It seems to me that would be the more reasonable course because, like I said, there's no evidence at all here to suggest in any way that the defendant, when she was personally present and through her counsel, that she ever had an issue with accepting the time that took this trial to May. So I don't think the state should be in a position now of simply saying, well, if the facts are kind of murky, then we ought to just go ahead and say it was a violation of speedy trial. I mean, in Wright, they did a harmless error. They said they couldn't do a harmless error analysis. And then when it came back on remand, they did the harmless error analysis. They still found that there wasn't a speedy trial issue and they ruled against the defendant. So I think we at the least could do the same here and ought to if you disagree.
Counsel?
Yes.
I have not been able to find anywhere in the record, and as I recall the statute, for the state to get a continuance to extend the speedy trial, the court must make a finding on the record of good cause. I'm not aware that was done in this case. Is that correct?
I don't believe so, because you're right. There was no hearing, and I did not see anything in the record in terms of an order or something actually extending. You're right. All I have is the emails after the motion to continue was filed.
All right, let's talk about the emails. Are the emails something that we can rely upon? Because they're not part of the actual record in the file. Is that correct?
As far as I understand, they were added to the record after the fact. So I mean, they're in the record on appeal, but they're
not admitted as part of the record in court, are they?
Right. No, as far as I understand, no, they're not. That's correct. I think they can be. Again, there was no disavowal of them by the defendant. There's never been a post-trial motion, any kind of motion for a new trial that says, hey, those emails can't be relied on. Again, I would just say at no point has there ever been anything, whether you're talking about for the 49 days from April to May, whether you're talking about response to the state's motion to continue, whether you're talking about a post-trial motion invoking speedy trial or lack of presence, there's never been anything. This is the first time we're hearing this on appeal. So it appears to me that the defendant never had an actual objection to this. These emails have never been disavowed. And certainly, like I said, the defendant had the opportunity, if they didn't think those emails were valid, to file a response to the state's motion in January and say, no, I never agreed to extend this thing to May. We still had almost a month left before the end of January. So I think at the least we should go back and there would need to be a fact finding there, because the defendant has the ability to waive speedy trial. I mean, that's clearly in the case law that a defendant can waive speedy trial, and I believe that's what happened here. But if there's more facts that need to be added to see that happened, I think we could accept that. But I think we can rely on them because they seem clear to be the court, and to say that the court wasn't involved, it's the district court that sent the email to both parties that said, does May 7th through 8th work for both of you? And the state came back and said, sure, as long as the defendant's willing to continue to waive speedy trial, giving some indication that they'd already done so. And the defendant's counsel said, yeah, we'll take May 7th through 8th is fine. We'll take the time. So
the email exchange that was added to the record, do you know where it came from? Was it attached to the state's motion to supplement the record? I mean, is that where it appeared? for the first time?
I don't believe it was attached to their motion on January 2nd. The date, if
No,
I
no,
recall.
no. I mean,
I'm sorry.
There was a motion to add those to the appellate record, correct?
Yes.
What I'm wondering is where they came from at that. I mean, were they attached to or filed contemporaneously with that motion saying these are here and we want them in the record?
To be honest, I can't answer that question, Your Honor. I don't know for sure.
All right, that's fine. You're kind of at the end and somewhat over your time based on the questions. If you want to take a minute to sum up, and we'll give Mr. Kittle a little bit more time as well, but you can give us your elevator.
No, I mean, I just think we have enough facts here to determine that defendant waived her right to speedy trial, and that her presence, she wasn't prejudiced by her presence, and that right to presence at a critical stage, as McDaniel says, is dependent on circumstances and context. And so I think that should control here. But barring that, I think that at the least it should be remanded for more fact finding to discern whether there actually was any opposition at that point to waiving speedy trial and her presence there. So I didn't make any points about issue 2. I think we're willing to stand on the briefs on that.
Okay. Mr. Kittle, go ahead and give us your rebuttal. I'll give you 4 minutes if you want.
Okay.
That much. So.
Thank you, Your Honor. The state is talking about how he thinks we have enough facts here, but then he starts talking about what he thinks happens in the case. Well, that should be an indication he doesn't really know what happened in the case, and we don't have enough facts. But what we do know is that, one, even if we take all the time prior to August 9th and charge that to the defendant and say that's the time that the clock starts running on speedy trial, the trial was still not held within 180 days after that point. There is nothing in the record, and I think Judge Schroeder, you asked this question, there's nothing in the record to indicate that Ms. Allen ever waived her speedy trial right. And what the state cites to for that proposition is its own motion asking for a continuance. But there's just nothing in the record. The problem we have here is that if we go back and say, oh, well, let's have a hearing, let's flesh these facts out, that doesn't change the fact that Ms. Allen's right to be present at a critical stage of the proceedings has already been denied. Her right to have her case brought to trial within 180 days has already been denied. And so I think that should be the end of the matter. Those constitutional and statutory rights have been denied, and there has to be something other than saying, well, let's just give the state another chance to do things right the second time around.
Counsel, in Wright, didn't the Supreme Court, under analogous, although I don't know that there would ever be these same circumstances again, but under analogous circumstances, the court said, we don't know whether defendant has agreed to this continuance or not, so we need to remand for a fact finding on that point.
That's what happened in Wright, but I would argue what we need to look at is the obligation is entirely upon the state here. The defendant in this case has never had to do anything to affirmatively assert her statutory right to a speedy trial. So it doesn't make any difference if back then she would have said, okay, let's do it. The state still has to bring her to trial within 180 days. And the problem is there's just nothing in the record to support what the state is claiming actually happened here. And in the absence of that, we have a violation of her statutory right. We have a violation of her constitutional right. And under those circumstances, I don't think this is justified in sending the case back to the district court so that the state can get a second chance to fill in the blanks as it chooses to, and to do what they think might have happened in the case. And the other thing, I don't know if I recall if I said this initially, but I'm submitting the second issue that I've raised in the brief on the brief for the court's consideration.
We always assume that unless there's an actual affirmative waiver like Mr. Hodgkinson's did in his earlier case. So, but anything further?
No, Your Honor. Thank you.
Okay. Well, that concludes the argument then. And again, I appreciate counsel, and I also appreciate that neither of you were involved in the trial and the creation of this record. You're just having to argue it now. So we will take this under advisement and get out an opinion as soon as we can. If you would kindly excuse yourself, however you do that by Zoom, we have yet one more case